Good morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. Remember that today is not your trial date, and so I encourage you to speak with your attorneys before speaking on the record today, because everything that we say is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present, both here in the courtroom with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom and are able to address your cases from here. If your attorney is not present in the courtroom when I call your name, you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have retained counsel for this specific arrest. You also need to know that this morning in the courtroom with me, I have present attorneys from the State Attorney's Office, as well as representatives from Confinement Status, Pretrial Supervision, and the Clerk of Courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at First Appearances if you are here on misdemeanors or municipal ordinance matters, but understand that that is dependent on what is going on with you personally and with your case. For those of you present this morning on felony matters or violations of probation, where the judge has already set a no bond hold, know that those cannot be changed or resolved here at First Appearances. Following today's hearing, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard by your division judge. Before I get started with our regular list today, let me just find out from Mr. Miller and Mr. Romero, do the jails have anyone that needs to be called out of turn?
Yes, ma'am. North Broward has asked that Mr. Beers on page 23 be called.
Okay, Beers.
We have Etienne on page 10. He's at the main. Mr. Stewart on page 16.
Okay.
And Mr. Almy also on page 16.
Almy? All right. Is that it?
And Judge, we have several people in court.
I have those here. I'm gonna go to the ones the jails requested to be called out of turn first, and then I'll go to the people that are signed in with us here in the courtroom. So we will begin with Austin Beers. You said he's at North Broward?
Good morning, Your Honor.
Good morning, Deputy. Good morning, Mr. Beers.
Good morning, Your Honor.
Mr. Beers, you're before the court this morning on 2 charges. Count 1 is a traffic capias related to a charge for operating without a valid license. Count 2 is attempted robbery by sudden snatching without a firearm or weapon.
Your Honor,
Yes.
actually, the information was filed as an attempted strong-arm robbery.
All right. So let me just make that correction on here. All right. I find probable cause for these charges, and I will hear from the parties at this time. Thank you.
Your Honor, I'm going to be requesting a $7,500 bond on count 2 with an order of no victim contact. Noting there was a witness to this incident, the level of violence alleged against that Mr. Beers committed against the victim. Additionally, in 2000, he has an open felony out of Palm Beach County for burglary of a conveyance, actually 2 counts of burglary conveyance, 1 count of grand theft, 1 count of petty theft. Showing a resisting without violence, 2018 out of Hillsborough County. 2018 criminal possession of stolen property out of the state of New York.
Thousand what? I'm sorry.
2018. And obviously, based on count one, he has another pending case that he failed to appear in court on. Nothing further, Judge.
Thank you. Mr. Miller?
But I just wanted to see if we can. Okay, Your Honor, I spoke with Mr. Beers. He's 19 years old. He's been living here in South Florida for about 4 years. He works in landscaping and lives with his mother. We are asked the court to keep in mind the age of this young man. I think most of Mr. Eric's priors were as a juvenile, and also the age of this case. This allegedly happened back in early November, and the state is just now getting around to arresting Mr. Beers on a non-in-custody capias. And notably, the alleged victim in the case did not pull a restraining order on Mr. Beers, and so I'm not sure how seriously everyone is taking this. I know Mr. Beers will be taking it seriously and intends to appear in court when called. $7,500 is a little bit out of his reach. We'd ask the court to consider something more in the neighborhood of $2,500.
Honor, if I could briefly respond.
Briefly, yes.
Yes. First, every prior I gave the court was as an adult, and he's already picked up all those in his he's 19, so he hasn't had much time as an adult. The state doesn't arrest anyone. Law enforcement does. So I don't know. And this information was filed in a reasonable amount of time after the alleged incident. And whether the victim seeks an injunction order of protection or not, I don't believe that defines how serious this allegations are.
And Judge, we're not offering a defense. We're just offering it as a mitigator.
Your Honor, I'm being advised apparently he did not show up for a sentencing hearing for the case in New York that I advised Your Honor of.
The bond on count 2 will be set at $5,000. There will be an order of no victim contact. Mr. Beers, so that you understand the no contact order, that means no being in the same place at the same time as the alleged victim in this case. That also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that?
Yes, Your Honor.
Thank you.
Thank you, Judge.
All right. Okay, next is going to be Joshua Etienne.
Judge, he's approaching. He's here at Main.
Thank you. Good morning, Mr. Etienne. You're before the court this morning on one charge of touch or strike battery, dating violence. I find probable cause, and I'll hear from the parties at this time.
Good morning, Your Honor. Mayhem Joseph on behalf of the state. At this time, the state will be requesting a $2,500 bond due to the fact that, based on his priors, he does have a 2019 battery. No action was taken, but that battery was allegedly committed on the same victim. That's in this case. Also has a 2019 possession of controlled substance, municipal ordinance that was withheld. 2019 possession of cannabis, adjudication withheld. 2016, 3 counts of grand theft in the 3rd degree, adjudication. 3 counts of uttering a forged instrument, adjudication. 3 counts of solicit to deliver cocaine, adjudication. 2016 domestic violence battery, adjudication. And a 2nd count that was declined. A 2016 burglary of a dwelling, adjudication. a 2014 burglary of unoccupied dwelling, adjudication withhold. And based on that, Your Honor, that's the basis for the state's recommendation.
Mr. Romero?
Judge, and speaking of Mr. Etienne, unfortunately, he's not going to be able to afford what the state has suggested. He's 23 years old. He's been here his whole entire life. He will be abiding by the court order as far as no contact. Judge, the only additional information I wish to provide the court is my understanding is when law enforcement showed up, Mr. Etienne was cooperative. So based on that, Judge, and this is a misdemeanor offense, I'm going to be requesting $1,000.
Well, according to the probable cause affidavit, it does appear that some of the alleged violence occurred in the presence of law enforcement, though I do note that once they told him to stop and return to the residence, he did comply with that request. Based on the information in the probable cause affidavit taken with the information provided in court today, I'm going to set the bond at $2,000. There will be an order of no victim contact. Mr. Etienne, so that you understand the no contact order, that means no being in the same place at the same time as the alleged victim. That also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that, sir?
Yes, ma'am.
Thank you. Next will be Kelvin Stewart on page 16.
He's approaching, Judge. He's in a wheelchair.
Okay, thank you. All right, good morning, Mr. Stewart. Mr. Stewart, you're before the court this morning on 2 charges. Count 1 is petty theft from a merchant, second offense. Count 2, trespassing of an occupied structure or conveyance. I find probable cause, and I'll hear from the parties at this time.
Judge, I spoke with Mr. Stewart earlier today. He wishes to resolve these offenses. I did advise him if there's state does offer to resolve this for a time served. I told him that one of the conditions is probably going to be no return. He has no problem abiding by that. He also said one of the problems that he's facing is basically housing. He has none. And I did advise him if he was able to resolve this case. I did advise him on Wednesday in the city of Fort Lauderdale in front of, I believe, Judge Barner. There's a program where they can provide assistance for his housing. So regardless what happens, I did advise him that would be a great idea. But he wishes to resolve this matter today, so we wanted to know if the state has a plea offer for him.
All right, I'll check with Mr. Linder. I do also just want to note, I encourage Mr. Stewart, obviously, to go to community court and take advantage of the services that are there. In the probable cause affidavit, the officer did note that on January 29th, he was given an NTA by Homeless Outreach for a separate trespassing charge and sent to community court, but he never appeared. So, of course, that doesn't stop him from going now to see if he can try to get some sort of help. But I just wanted to point that out. Mr. Linder, does the state have an offer?
It would be a withholding court cost.
Withhold court costs, no return?
Let me talk to him.
Okay.
Judge, he wishes to accept the state's offer.
All right. Mr. Stewart, will you please raise your right hand?
He's making an attempt to, Judge.
Okay, all right, that's good enough for me. Mr. Stewart, do you swear or affirm to tell the truth?
Oh, say it again, I'm sorry.
Yes, ma'am.
All right, thank you. And if you do have your hand up, you can go ahead and put it down. Mr. Stewart, do you understand everything that's been discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
All right.
Have you ever been treated for mental or emotional illness?
Yes, ma'am.
Is there anything about that illness today that impacts your ability to accept this plea?
No, No, ma'am.
All right. And do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yeah.
Do you understand that, sir?
Yes, ma'am.
Okay. And Mr. Stewart, what plea do you wish to enter? Guilty or no contest?
No contest.
No contest?
All right.
He said no contest, Judge.
I accept your plea and I find that it's freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs, and there will be a no return order to the 7-Eleven that's at issue in this case. Do you understand that, sir?
Yes, ma'am.
All right, thank you. Good luck to you, Mr. Stewart. Next will be Roberto Almi on page
He's a
16.
Judge?
Thank you. All right. Good morning, Mr. Almi.
Hello.
Mr. Almi, you're before the court this morning on 3 charges. Count 1, exposing sex organs in public. Count 2, disorderly conduct or breach of the peace. Count 3, resisting an officer obstructing without violence. I find probable cause for these charges. I believe pretrial is standing up.
Your Honor, he's currently on pretrial in case number 20000249 Judge McHugh placed him on pretrial on February 3rd for a battery pretrial. Is asking that you revoke his pretrial at this time.
It's put on pretrial on February 3rd
Yes,
of this year.
yes.
All right, based on pretrial's request, I'm going to grant the request to revoke Mr. Almi's pretrial services. Once again, just for the record, that's case number 2000249MM10A. So at this time, I will hear recommendations from the parties as to bond on both the battery case that was on pretrial, as well as the case that's before me today.
Judge, Mr. Almy is not working. He's not on disability. So financially, he's not in a position to put any sort of bond, but I'm going to be also requesting a photo order so we can photograph the injuries that Mr. Almy sustained.
Your Honor, I'm going to ask that this matter be transferred to Judge Lerner Wren.
Okay?
No objection.
All right. I'll sign the photo order. I will sign the order transferring it to Judge Lerner Wren. I do need a bond set, at least in the case that was on pretrial, though.
I'm just requesting a $1,000 bond.
All right. The bond in the battery case will be set at $1,000. I'll leave the standard bond in place on the case that's before me today. And as I said, I will sign those orders on both cases.
Your Honor,
Yes.
the Spanish interpreter is here for Stephen Ramirez Tavares, who is on page 28 of the court's docket. And we have an argument regarding probable cause for count 1.
Okay, one moment. What was the name? Ramirez?
Ramirez Tavares, yes ma'am.
Stephen is the first name. Stephen Ramirez Tavares.
Okay. Is that the only case that's going to require a Spanish interpreter?
The only one I'm aware of.
In Maine, as far as I'm aware, yes, Judge.
All right, we'll double check after. For my interpreter, will you please raise your right hand? Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
I do, Your Honor.
Thank
Zachary
you.
Shapiro, Shapiro, Spanish interpreter.
Thank you, Mr. Shapiro. All right, good morning, Mr. Ramirez Tavares.
Buenos días, señor Ramírez Tavares.
You're before the court this morning on one charge of possessing a weapon on school property.
Usted ha comparecido ante el tribunal esta mañana acusado de un cargo de poseer un arma de fuego en propiedad escolar.
Mr. Miller, I will hear your argument at this time.
Señor Miller, voy a escuchar su argumento.
So Mr. Ramirez Tavares is charged with possessing a weapon on
Al
school
señor Ramírez
property
Tavares lo han acusado de poseer un arma de fuego en propiedad escolar.
under Florida Statute 790.1152B.
Bajo la ley de la Florida 799.1152B.
Judge, as near as I can see, to be required, reads a person who willfully and knowingly possesses any electric weapon or device, destructive device, or other weapon as
La ley
defined.
dice que
He's gotta
cualquier
interpret it.
persona que esté en tenencia de un dispositivo electrónico o algún otro tipo de arma
in Florida Statute 790.001,
la ley de la Florida 790.001,
including a razor blade or box cutter,
que incluye un bisturí o una navaja,
and et cetera, as in violation of, it's a felony in the third degree. However,
etcétera, etcétera, se considera un quebrantamiento de la ley y es un delito grave de tercer grado. Sin embargo,
the section of Florida statutes referred to, 790, sorry,
la sección de la ley de la Florida a la que se refiere, que es
790.001 definitions,
790.001, definiciones,
specifically excludes a common pocket knife from being defined as a weapon.
en particular excluye las navajas pequeñas que se pueden llevar en el bolsillo como armas.
In the probable cause affidavit, and the second to last paragraph,
Y en la denuncia,
the
en el
item that
penúltimo
was
párrafo,
recovered is described as a silver folding blade knife.
dice que el artículo que encontraron es una navaja plateada doblable,
That
plegable.
would tend to indicate that this is a common pocket knife.
Eso me indica a mí que sería una navaja de bolsillo pequeña.
Had it been anything other than a common pocket knife, the arresting officer would likely have described it as such.
Y si hubiesen encontrado algún tipo de arma diferente a una arma pequeña plegable, el agente que acudió a la llamada hubiera dado una descripción alternativa.
And so, Your Honor, within the four corners of this document, I do not believe there is probable cause to hold Mr. Ramirez Tabarez on this charge.
Por eso, si tomamos en cuenta toda la denuncia, creo que no hay motivo fundado para tener preso al señor Ramírez Tavares bajo este cargo.
Mr. Linder, state's response.
It's fine,
La
Mayor. We'll
respuesta de la
come back in
Fiscalía.
24 hours.
Vamos a pedir 24 horas.
All right, based on the argument and request of the state,
Bueno, basado en el argumento y la petición de la Fiscalía,
I will find no probable cause as to the charge,
hallo que no hay motivo fundado para este cargo.
but I will give the state 24 hours to perfect.
Aún así, le voy a dar a la Fiscalía 24 horas para perfeccionar el cargo.
That means that Mr. Ramirez Tabarez will be back tomorrow morning.
Quiere decir que el señor Ramírez Tavares regresará ante mí mañana a la mañana.
Thank you.
Thank you, Your Honor.
All right. Is there anyone else at Maine that requires a Spanish interpreter?
Not at this time, Judge.
All right. Anyone at Paul Ryan, Conti, or North Broward that requires a Spanish interpreter? All right. Thank you, Mr. Shapiro.
My pleasure, Your Honor.
Okay, at this time, I'm going to go to cases that have signed in. I'm just going to go in order that they were signed in. First up will be, if they are present at the jail, on page 2, Olivia Hines. She has family present.
He's here, present, Judge. Man, come on up, man.
All right.
Because there are several members, I'm sorry, the alleged victim is here today to tell the court that he is not going forward with this case.
Okay, well, don't get ahead of me. Don't get ahead of me.
Yes, ma'am.
All right, Ms. Hines, you are before the court this morning on one charge of aggravated battery causing bodily harm or disability, dating violence. I do find probable cause for the charge. And sir, let me just first start by asking you, are you here to observe or to speak this morning?
Yes, ma'am.
You're here to speak?
Yes, ma'am.
Okay, so I just want to say a couple things to you. And this is what I say to everyone who comes to speak at first appearance hearings. Number one, everything that we say is being recorded and can be used against you and potentially her at a later date. Do you understand that? So I say that to you because I don't know if you've already provided a sworn statement to law enforcement. You're here without an attorney this morning, and so I just want to make that clear to you. You understand? All right, and if you do want to speak, then I'm going to place you under oath, and then I'll let you speak. I'm going to ask you to speak into the microphone there in front of you so that they're able to hear you over at the main jail, all right?
Yes.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
All right, and will you please state your name and spell your last name? Just remember speaking to the mic.
My name is Chadwick Little, Little.
All right. All right, Mr. Little, what is it that you want to tell us this morning?
Yeah, I would not like to pursue, the charges, and
I
I'm
think
not in
they're
fear.
having a hard time hearing you.
Yeah, I can't hear him.
I would like to not to pursue the charges. And I'm not in fear of my life. I don't feel threatened, and the nature of the charge is not, that serious of what really happened. And also ask that, if the court could have like a no harmful contact, if it's, up to you, and that Aura, I was asking, can she be released on her own recognizance? Once again, it's up to you, Judge, and if it's not an RR, then a more reasonable amount of bond.
All right, so Mr. Little, I appreciate what you've said to me today.
Yes, ma'am.
I want you to understand a couple of things. Number
ma'am.
one, I'm not dealing with anything regarding the underlying facts of the case.
Yes, ma'am.
Okay, so today I'm only addressing bond and release conditions.
Yes, ma'am.
Because of the nature of the circumstances, I'm just gonna tell you up front, there probably will be a no contact order. That is, generally speaking, my procedure in this courtroom, because I have a duty to read into what's going on in the probable cause affidavit and to take into consideration everything else that's surrounding the case today, okay?
ma'am.
So at this time, I'm going to listen to the recommendations from both of the attorneys, and then I'll make a decision, all right?
Yes, ma'am.
Okay, all right, so Mr. Linder, go ahead, please.
Thank you, Your Honor. And I have been advised already of Mr. Little's position,
All right.
and I understand that, take that into consideration. I'm going to be requesting a $5,000 bond, no victim contact. This is based on the level of violence alleged in the probable cause affidavit. Also taking into consideration an individual sought and obtained a temporary order of protection injunction against Ms. Hines in Dade County last month. That individual was also the listed victim of a battery last year in Dade County that was ultimately dropped. Nothing further, Judge.
Mr. Romero, I'll hear from you at this time.
Judge, as you heard from Mr. Little, basically he's not in fear. He does not want Ms. Hines prosecuted. So ultimately, one of the things that the court can take into account is the strength of the state's witnesses. If the victim is here, he's probably going to go to the state attorney's office, file a waiver of prosecution. So ultimately, this case might not ever be filed. Also, he does want contact, and he wants to release RR. Now, I do understand because of the situation. I did advise Ms. Hines that most likely the court is going to order no contact. She will respect that order and abide by that order. Now, she will be. They do live apart. My understanding is she resides with her mother. But ultimately, I believe Mr. Little is going to be the person that posts her monetary bond. My understanding is he's a cook. He's a cook, and his financial resources are limited. $5,000 is something that he's not going to be able to afford. I'm going to be asking the court to consider a $1,000 bond. Now, Ms. Hines is working. She just got a job at Seasons 52 about 8 months ago, where she's preps food, only making $12.50. I believe the prior that the state was referring to was ultimately dropped, a conscious decision by the state to drop the case. But I believe a reasonable bond would be at about $1,000, Judge.
I'm gonna set the bond at $1,500. There will be an order of no victim contact until further order of the court. Ms. Hines, so that you understand the no contact order, because this applies to you, that means that until there is another order of the court lifting this no contact order, that means you are not to be in the same place at the same time as Mr. Little. That also means no phone calls, no text messages, no third-party contact, and no social media contact. Do you understand that, ma'am?
Yes.
Thank you.
Yes.
All right, thank you. Good luck, Mr. Little.
Good luck.
All right. Next will be Oceanette Hicks on page 5. She has,
Judge, one thing I've just been apprised of, I believe Ms. Hines and Mr. Little, work in the same location or in the same building. At the Galleria Mall. I believe separate floors. I just want to make sure that the court is aware of that and is okay with the fact that they work basically at the same mall.
that's fine with them working at the same mall as long as they're in different places, but that means no riding to work together, no talking to each other on your breaks, no contact. I'm being very clear about it. All right, thank you. Okay, all right, so next is gonna be Ms. Hicks. She has family present in the courtroom.
She's a person, Judge?
All right. Good morning, Ms. Hicks.
Good morning.
Ms. Hicks, you're before the court this morning on 3 charges. Count 1, aggravated assault with a deadly weapon without intent to kill. Count 2, touch or strike battery. Count 3 is criminal mischief between $200 and $1,000. I find probable cause for these charges, and to the family members that are present, are you here just to observe this morning or to speak?
I'm here to speak.
Okay, so you heard what I said in the prior case, all right? So if you do want to speak, then I'll swear, are you both speaking or just you?
I just speak.
Okay, so I'm gonna place you under oath, and then I'll have you state your name. I'm just gonna ask that you speak into the mic so that they can hear you, okay?
Yes, ma'am.
All right, do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, will you please state your name and spell your last name?
My name is Shantavian Tucker. Last name Tucker.
All right, thank you, Mr. Tucker, and what is it you would like to tell us today?
I'm here to say that she's a caring mother. She's in school. She has a lot going for herself. I don't know what happened, but we have 4 children. We just got engaged last year. We're getting married in June, and I need her home for my children. All my children are straight A students, and they have no clue that where she is. I've been trying to cover it up. I just need her home.
Okay. Does she live with you?
Yes, ma'am.
All right. Is that the residence, that's 3680 Oaken Preserve Way, 4306?
No, ma'am. We live at 154 Northeast 38th Street, Oakland Park, Florida.
All right. Okay. All right, so at this time, I'm going to hear recommendations from the attorneys, and then I'll make a decision, all right? Okay, go ahead, Mr. Linder.
Your Honor, as far as history, I'm only showing a couple of misdemeanor drug charges, nothing nothing aggravating with respect to this matter. Taking into consideration all the charges, since there's no bonds attached to counts 2 and 3, I'm requesting a $5,000 bond on count 1. Based on the level of violence that Ms. Hicks threatened the victim with a knife, there's an allegation that she physically attacked the victim and that the victim suffered lacerations to her arms, neck, face, and legs. Would be asking for no victim contact as well. And I would also note that according to the report, there was a witness who provided a sworn statement that supported the victim's allegations.
Mr. Romero?
Judge, basically, as you heard, Ms. Hicks, not a convicted felon, she, basically, as far as felony offenses, has a clean record. She's a registered voter here in our community. She's been here her whole entire life. She's 30 years old. Her and her fiance are raising their 4 children. They live here locally in Oakland Park, where they rent. They do not own. Their monthly rent is about $1,375 per month. Now, I do understand as far as the serious nature of the allegations. I did hear from Mr. Linder that there was a witness, but Ms. Hicks also has her witness, and she is looking forward in her day in court and disputing these allegations. Judge, she is working. She works at a place called Karen's Little Treasure. It's a preschool where she's been there employed for about 3 years, making about $12.50 an hour. Besides that, she's studying, trying to get ahead in life in order to provide for her children. She's at Kaiser University studying psychology, and she's paying that for their studies through financial aid. My point in all this is her financial resources are very, very limited. Judge, I'm going to be asking for the court to consider a $2,500 bond on Ms. Hicks' behalf.
I set the bond on count 1 at $3,500. There will be an order of no victim contact. Ms. Hicks, so that you understand the no contact order, that means no being in the same place at the same time as the alleged victim. That also
Yes.
means no phone calls, no text messages, no third-party contact, and no social media contact with this person. Do you understand?
Yes, ma'am.
All right, thank you. Thank you, Mr. Tucker. Next will be John Debitus on page 10. He has family present in the courtroom.
Mr. Devitt, come on, please.
Judge,
He's,
Mr.
present,
Devitt's
Judge.
sister is present and is here to support her brother.
All right. Good morning, Mr. Debitus.
Morning, Judge.
You're before the court this morning on one charge of touch or strike battery, domestic violence. I find probable cause. And ma'am, are you here just to observe or to speak this morning? Okay, all right, that's all right. Okay, so at this time, I will hear from Mr. Linder with the state's recommendation.
Your Honor,
Oh, excuse me, I'm sorry, Mr. Joseph, go ahead.
no problem. At this time, the state's recommendation is it's going to be $1,000.
Judge, we can't hear the state at all.
The state's recommendation at this time is going to be $1,000 with no victim contact, Your Honor.
Okay.
And the only
Judge, considering the circumstances, $1,000 is reasonable.
All right. Okay, so based on that, the bond will be set at $1,000. Mr. Debitus, there will be a no contact order. That means no being in the same place at the same time as the alleged victim. That also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand?
Yes, ma'am.
Thank you. Good luck. Next will be name Cato on page 12. His private counsel is present in the courtroom.
Good morning, Your Honor. Steve Lopez on behalf of Mr. Cato.
Good morning, Mr. Lopez.
Who's your private attorney?
Judge, I'm gonna go ahead and concede that on the four corners of the A form, there's probable cause, but I want to inform the court. This is a delayed case. My client came to me back in November when the alleged victim was telling him there was a breakup, that she was gonna make these allegations up, whatever. I tried to contact Miramar Police and provide them with the plethora of testimony, evidence, including her admissions that she had falsely accused them of this battery by strangulation. I offered them for a proffer by Mr. Cato at the time. There were several witnesses I provided that subsequent to this incident, the victim began to stalk Mr. Cato, drive by his house, park on his driveway where he lives with his mother, refusing to leave the driveway and what have you, to the point where several times they had to contact the police. And they didn't care. They didn't want to hear any of that evidence. They didn't want to look at any of that. They just wanted to walk the warrant through. I know this is not the time for that. I will deal with that with the felony screening unit, which in Broward County is a very good unit. However, I want the court to be aware. As an officer of the court, I'm not going to come here and fabricate facts or make up stories that aren't true. The truth is, these allegations were fabricated by the victim. She acknowledged it. I have evidence of it. And the police simply just walked the warrant through. But unfortunately, based on the four corners of this A form, anyone that reads it, I have to be objective and admit that it does show probable cause. The purpose of my telling the court that was my client has no priors, and I'm asking the court to, and he has no problem staying away from the victim. He's been trying to do that, but the victim continues to follow him, stalk
Well, did
him.
he get a restraining order against her?
He did not, and that was against my legal advice, and against his mother's motherly advice. You know,
Sometimes you gotta listen to mom.
sometimes you gotta listen to mom. If you're not listening to your attorney, you definitely gotta listen to mom. But the issue is, I'm telling the court, he has no problem agreeing to a stay away order because he's not going to contact her, not gonna see her. But I'm asking the court for a reduced bond. He has a job. He doesn't qualify for the services of the public defender, which is why I'm retained. But he's at that benchmark. And I'm asking for the court to take that into consideration while giving him a lower than the standard bond, or just giving him a reasonable bond, so that he can fight these allegations.
Okay, well, let me start with Mr. Linder's recommendation, and then I'll come back to you.
And Your Honor, I just want to first clarify, this isn't based on a warrant, this is based on a not in custody capias. law enforcement can't take anything into consideration to not arrest him on the capias. So whatever information counsel had, that really has no bearing on the officers executing the not in custody capias, one. Two, from counsel doesn't have any direct knowledge unless he was present when the alleged victim made any alleged statements to Mr. Cato. So for him to say he's an officer of the court, I don't doubt everything he's advising of has been relayed to him by his client. That doesn't in and of itself make it true. I would note that the officer or the detective that took this statement details the physical injuries suffered by the alleged victim, which would corroborate her allegations about the violence that was committed by Mr. Cato. Our office also had contact with the alleged victim this morning. She voiced concerns about mental health. Frankly, I can advise the court what I've been advised. She advised he needs to get help. From what I was told, she wasn't voicing anything punitive, so I think that's something the court should take into consideration, because counsel's describing someone essentially acting in vengeance that you would think would want to get Mr. Cato punished. She described his behavior and past behavior as harmful. She does want a no victim contact order. I see no history, Your Honor. Based on the level of violence and an allegation of strangulation, I would be requesting a $7,500 bond on count 1, a $1,000 bond on count 2, and an order of no victim contact.
Judge, and I may just voice one thing. Having been a violent crimes detective in Broward County for 10 years, prior to being a career criminal prosecutor in Miami-Dade County and being a defense attorney, I can tell you that I contacted the detective the day the incident was reported to him. And yes, as a detective, before you file an in custody or out of custody probable cause affidavit, it should be based on the totality of the facts. This isn't something where he walked a warrant through and then I decided to go ahead and provide him the evidence. The girl, the alleged victim, told the defendant that she was going to call the police and she was going to ruin his life. And on that day, the same day of the alleged incident, he came into my office. I contacted the Miramar Police Department and offered to provide him the text messages, including the Facebook messages and Instagram posts where she posts these injuries that weren't there the day after the incident. So that's and the detective did not speak to her the day of the incident. This was a delayed reporting.
Okay,
The issue is that I am not talking to this court about what my client has told me, but what my eyes have seen. Now, unless it's a fake number that doesn't belong to the victim, which I've run a TLO investigation report on it. It's a TransUnion tool that we use to identify numbers, witnesses, and addresses, and it comes back to her. Unless someone else sent the message. I know I can't prove she sent the message, but the messages that I've seen with my own eyes. This isn't just me taking my client's word for it. I just wanted to put that on the record, Your Honor.
Okay. All right. So, Mr. Lopez, what are your monetary recommendations?
I'm asking for a $5,000 bond as to all counts. Stay away order stipulated. He will stay away from the victim.
Obviously, for first appearance purposes, I have very limited information to go off of. What happens after today, that'll be determined between the parties with whatever evidence is available. For the purposes of today's hearing, the bond on count 1 will be set at $5,000, and the bond on count 2 will be set at $1,000. There will be the order of no victim contact.
Mr. Cato, if she continues to call you, drive by your house, you report it to the police, and you get an injunction. You don't initiate contact with her. You understand that?
Mr. Cato, will one of the deputies turn the mic on there, please? Okay, thanks, Mr. Romero. All right, Mr. Cato, you heard what your attorney has said to you. Now, I'm just going to clarify to you on our end of things, the no contact order that's going to apply to you means no being in the same place at the same time as her. That also means no phone calls, no text messages, no third-party contact, no social media contact initiated by you. Do you understand that?
Yes, I do.
Okay, all right, thank you very much.
Thank you.
Good luck, Mr. Lopez.
Thank you. Thank you, Your Honor.
Thank you. Alright. Next will be, is Mr. Kimmick here? Okay. Alright, next is gonna be Callie Gissendanner on page 9. This is a change of charge.
Is it North Broward, Judge?
Is it North Broward?
She's in North Broward. Joe Kimmock with the Regional Conflict Council on Ms. Gissendanner's behalf.
Thank you, Mr. Kimmick. Good morning, Ms. Gissendanner.
Good morning.
All right, so we are here on a change of charge this morning, and Mr. Linder, you know, I always like to confirm these. My paperwork is showing that the original charge was for premeditated murder, and it's being changed to attempted first-degree murder. Is that correct?
Yeah, technically, yes, it was a booking issue, Your Honor. I have the copy of your findings from the original first appearance.
Yes.
You wrote in attempted
Okay.
murder premeditated. You made a finding of proof evident or presumption grade
All right.
for first appearance purposes only, in order Ms. Gissendanner to be held no bond.
Okay. All right. So then, Mr. Kimmock, I assume you have no objection to this. If you do, correct me if I'm wrong.
No, I saw that you had already made those findings back on the 21st of January.
Okay.
She has an arraignment next week. We've already filed a motion for Arthur hearing.
Okay, great. So then what I'm gonna do, since this is just a technicality and I've already made the findings based on the attempted murder charge, I'm just going to keep the same findings in place and I'll indicate on here proof evident presumption great without prejudice. So Ms. Gissendanner, just so you understand, the hearing today is just a technicality, so it doesn't change the position that you're in. Mr. Kimmock is telling me that you already have hearing dates set, so you're gonna be seeing your division judge. Is that next week, you said?
Yes, Judge.
All right, so next week you'll see your division judge, okay?
Okay.
All right, thank you very much.
Thank you, Judge.
Thank you.
Okay, and our city cases we'll have to wait for now. All right, if there's no one else to be taken out of term besides the city cases, while I wait on the attorney to come back, we will go down the regular list. First up will be Michelle St. Surin.
She's supposed to be here in North Broward, John, but because she was misdemeanor domestic, they sit her down.
She's at the main, Judge.
They said she's at Maine. Okay, let me go over to Maine, deputy, hang on. Hold on. Okay, I'm sorry, what was that, Mr. Romero?
She's here, I mean.
Okay, all right. Good morning, Ms. St. Surin.
Good morning.
Ms. St. Surin, you're before the court this morning on 2 charges of touch or strike battery, domestic violence. I find probable cause, and I will hear from the parties at this time.
Your Honor, based on the facts and the probable cause, the state's recommendation for count 1 would be 1,000, and for both counts, count 1 and 2,
Okay.
with no victim contact. And just for Your Honor, I do show that she currently has a pending petty theft, a misdemeanor petty theft at this time. Yeah.
Broward?
Yes,
Judge,
Your Honor.
considering the totality of the circumstances, at this time, we're not asking for anything, Judge.
All right, then based on that, the bond on each count will be set at $1,000, and there will be an order of no victim contact. Mr. Romero, I don't know if she resides with the alleged victims or not. I assume that you've discussed that with her.
I have, Judge. She'll be living separate and apart.
Okay. All right, so Ms. St. Surin, so that you understand the no victim contact order, as to both alleged victims, that means no being in the same place at the same time. It also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand?
Yes, ma'am.
All right, thank you.
Thank
Judge,
you.
we're gonna request a photo order as well.
All right, I'll sign that. Next will be Carol Garriga.
Ms. Curry, come on. She's approaching, Judge.
Thank you. Good morning, Ms. Garriga.
Good morning.
You're before the court this morning on 1 charge for touch or strike battery, domestic violence. I find probable cause, and I will hear from the parties.
Yes, Your Honor. The state's recommendation is going to be count 1, $2,000. Reason for the recommendation is based on her priors. She does have a prior
Judge,
battery
that's
against the
reasonable.
same victim that was in 2019 that was dropped.
Okay. All right,
And-
and
That's all. I do show a misdemeanor possession of cannabis. That's also dismissed.
Okay, all right. Based on Mr. Romero's concession, the bond will be set at $2,000. There will be an order of no victim contact. Ms. Garriga, so that you understand the no contact order, that means no being in the same place at the same time. It also means no phone calls, no text messages, no third-party contact, and no social media contact. Do you understand?
Yes, ma'am.
Thank you. June Parague.
But that's a medical reset.
Okay, thank you. Rita Almeida de Oliveira.
I think that's also a medical reset.
Okay.
But it doesn't say where she is, so I don't know.
Sheila, can I just confirm? It's medical loan? Okay, thank you. Next will be Chantherat Wongpresorn.
Judge, this young lady came through yesterday. She speaks Thai. I've already put a call into the court interpreters. They're gonna call me back when we can arrange the Thai interpreter.
All right, so I'll just leave her on recall for now until we know. It's Wongpresorn. It's only on, it's the immigration hold ad charge. I'm sorry? Okay, all right, I'll just leave her on recall and we'll check on her in a little bit. All right, next will be Linda Lupo. Thank
Howard.
you. North Broward, do you have Linda Lupo?
Courtroom.
Thanks, Deputy.
You're welcome. Come on, do it.
Good morning, Miss Lupo.
Good morning.
Miss Lupo, you're before the court this morning on 4 charges. Count 1 is a felony capias related to a charge for possession of cocaine. That has a no bond hold on it set by your division judge. Count 2 is a misdemeanor capias for possession of drug paraphernalia.
Correct.
Count 3 is a U.S. Marshal hold, which has a no
Right.
bond hold. Count 4 is a misdemeanor capias for possession of drug paraphernalia, which also has a no bond hold on it. I find probable cause, and Mr. Miller, I do see that the misdemeanor capias has a $500 bond, but in light of her no bond holds, is there anything you want to add?
Not at this time, Judge.
Okay, so, Ms. Lupo, I do see you're gonna be seeing your division judge on Monday morning.
Monday.
All right?
Right.
All right,
Yeah.
good luck to you, ma'am.
Thank you.
Thank you. Rosemary Cruz Butrago. You have a correction? Okay. Yes.
Violation of pretrial.
Pre-trial. All right. I'll make a correction on here. Thank you very much. Which facility is she at? Do we know? Thank you.
She was at main judge, but I believe she's a medical reset.
Oh, she is? All right.
Yes, Judge.
All right. She's a medical reset, yeah. All right, next will be Brianna Needham.
She's here present, Judge of Maine.
Thank you. Good morning, Miss Needham.
Good morning.
Miss Needham, you're before the court this morning on 7 charges. Count 1, grand theft between $10,000 and $20,000. Count 2, obtaining property over $20,000 by fraud. Count 3, grand theft between $750 and $5,000. Count 4, illegal use of a credit card. Count 5, fraud, use, or possession of identification of another person without consent. Counts 6 and 7 are felony probation violations, which have no bond holds. I find probable cause, and I will hear from the parties at this time.
Judge, considering she has no bond holds, nothing to add from the defense.
All right. Nothing further.
Just ask for no victim contact.
All right, there will be a no victim contact order. Ms. Needham, that means no being in the same place at the same time as the alleged victims in this case. That also means no phone calls to them, no text messages, no third-party contact, and no social media contact. Do you understand?
Yes.
All right, and you'll be seeing your division judge on Monday morning to address the probation violations. Yvette Blatch,
I've been advised she's bonded, Judge.
thank you. Charlotte Mankey Skaggs.
Judge, she's at North Broward.
Yes, Your Honor.
Good morning, Miss Mankey Skaggs. You're before the
ma'am.
court this morning on one charge of carrying a concealed firearm.
By accident.
I
Okay,
find probable cause. Miss Mankey, I'm just going to advise you not to say anything about the facts of your case. I'm only addressing bond and release conditions, and I'd rather you not give your attorney, Mr. Miller, a heart attack this morning before I end the court session.
Thank you, Judge.
All right. At this time, I will hear recommendations from the parties.
Judge, we're looking for pretrial release or ROR on this case. She accidentally, according to the PC, she brought a handgun into the courthouse. She was advised me she was here to swear out a restraining order, that the handgun was new to her, and the reason she got it was because of the restraining order, because the individuals involved, and she purchased it the night before. She's been here in South Florida for about 2 months. She moved here from Dallas recently. She does have a lease on the apartment where she lives. She does work in retail and in marketing. And again, I could not find a restraining order in the Odyssey, but it sounds like it's fresh, and we know that the clerk is sometimes slow in getting things online. There was no harmful intent here. This was an accident, Judge. She's not going anywhere. She's not going to be avoiding this. Hopefully the state will see its way clear to drop this charge, but for the time being, we're just asking for ROR, or pretrial release, please.
Well, before Mr. Linder speaks, I just want to note, per the probable cause affidavit, she did enter the courthouse with a .380 firearm along with 50 rounds of ammunition, which seems a bit excessive.
That means she has a box. So that doesn't mean she was here to start a war,
It's in the probable
Judge.
cause affidavit. Mr. Linder, go ahead.
Yes, Your Honor, I'm gonna be actually requesting a $5,000 bond. I understand Mr. Miller's argument, but frankly, I can't know what is in Ms. Mankey Skaggs' mind at this point in time. She has no record, but I believe in an abundance of caution, based on all the considerations and factors, that the bond the state is seeking is appropriate. I'm sorry, one moment, Your Honor. Could I just have a moment? Okay, I am showing a theft between $1,500 and $20,000 out of the state of Texas. It's a 2015 case. Looks like it ended up getting pled out in 2018, and a 2005 DUI.
And so nothing violent, Judge, and clearly, this, Judge, was an accident. And I understand that the state's concerned, but bumping the bond 500% based on nothing doesn't make any sense to me at all.
Well, I understand what you both have said. I understand that your position is that it was an accident, but in this situation, I also just noticed on here, the probable cause affidavit also notes she doesn't even have a concealed weapons permit. So it should not even have been on her person in the first place. Nor should it have been brought into the courthouse, both a firearm and 50 rounds of ammunition. That obviously is a great concern, especially in light of the fact that you're telling me she was coming on a restraining order. I don't know what's going on in Miss Mankey Skaggs' mind, but I understand we're only here to deal with first appearance today. So I'm not going to ROR her based on these allegations.
Judge, would the court keep the bond as set?
I'm gonna set it at $3,000.
Yes, ma'am.
Thank you.
Oh,
Next,
Judge, for
yes.
Ms. Menke, we need a photo order and a phone order.
That's
please.
fine.
Thank
I'll
you.
sign this. Next will be Ally Doom. Is Mr. Doom?
He was brought from North Broward.
Okay, all right. Okay. Good morning, Mr. Doom.
Morning.
Mr. Doom, you're before the court this morning on one charge of touch or strike battery, domestic violence. I find probable cause, and I will hear from the parties at this time.
Judge, he's wanting pretrial release, and that's what we're going to be asking for, Judge.
Your Honor, the state's gonna be asking for, based on the facts and his priors, a $2,000 bond. I do show that he has a 96 aggravated assault with a firearm and robbery, both adjudications out of Miami-Dade. 1995, 3 counts of robbery, armed with a weapon, adjudication. 94 aggravated battery, and a shoot, throw, deadly missile. Those were dropped. 92 battery and a burglary in an occupied dwelling at Miami-Dade. That was dropped. So based on that, the state would be asking for 2,000 plus what's the fact from the probable cause affidavit, Your Honor.
But did you say that the most recent was 1994? Is that correct?
96, Your Honor.
96.
Yeah.
Oh, the 2010 VOP? Jacksonville. Mr. Romero, does Mr. Doom reside with the alleged victim?
Judge, my understanding is a boarding home in which I believe him and the alleged victim are staying there. So, yes, Judge.
All right. The bond will be set at $1,000. There will be an order of no victim contact. Mr. Doom, so that you understand the no contact order, that means no being in the same place at the same time as the alleged victim. That also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand? Thank you. Juan Morales.
Mr. Morales is approaching, Judge.
Thank you.
Mr. Morales, come on up, please.
Good morning, Mr. Morales. You're before the court this morning on 9 charges. Count 1, battery causing bodily harm. Count 2, domestic battery by strangulation. Count 3, child neglect with great bodily harm. Count 4, touch or strike battery, domestic violence. Count 5, resisting an officer, obstructing without violence. Count 6, driving while license suspended, habitual. Count 7, resisting an officer, obstructing without violence. Count 8, aggravated child abuse. And count 9 is felony battery. I find probable cause for these charges, and I will hear from the parties at this time.
Your Honor, first, Mr. Morales' history. He was arrested for a battery against the same alleged victim, the adult victim, last year. That was dropped. 2018, possession of alprazolam, he violated probation. 2018, possession of alprazolam, carry and concealed firearm, violation of probation. 2010, criminal mischief, resisting without violence, there was an arrest for battery, that was dropped. Your Honor, based on the level of violence, which frankly speaks for itself in this case, the aggravating nature of the allegations, and my grave concern for not only the alleged, but for both victims, which includes a 4-year-old child, I'm going to be requesting $15,000 bonds on counts 2, 3, 4, 8, and 9. Should he post the bond pretrial release with a GPS monitor level 1 and an order of no victim contact?
Okay, Mr. Romero.
Judge, Mr. Morales has been here his whole life. He's 29, he's not working, and from what he advises me, he's not in a position to post any sort of monetary bond, nor can anyone post a bond on his behalf, Judge.
The bond on counts 2, 3, 4, 8, and 9 will be set at $15,000. Mr. Morales does post a monetary bond. He'll be placed on pretrial supervision with a level 1 GPS monitor. There will also be a no victim contact order, which will apply to both the adult alleged victim in this case as well as the minor alleged victim in this case. Mr. Morales, so that you understand, the no contact order means no being in the same place at the same time as the alleged victims. Since you'll be wearing a GPS monitor, that will include a 500-foot stay away order from both of the alleged individuals. The no contact order also means no phone calls, no text messages, no third-party contact, and no social media contact. Do you understand that, sir?
Yes, ma'am.
Thank you. Sinclair Ellis.
He's here present, Judge. I mean, come on up, Mr. Ellis.
Thank you. Good morning, Mr. Ellis. Mr. Ellis, you're before the court this morning on 3 charges. Count 1, resisting an officer, obstructing without violence. Count 2, aggravated assault with a deadly weapon without intent to kill. Count 3, touch or strike battery, domestic violence. I find probable cause, and I'll hear from the parties at this time. Let me just double check with Sheila. On count 3, it's showing as no bond, but I assume that's supposed to be, yeah, all right, I'll make the correction on that. Yeah, I made the correction.
Your Honor, I'm requesting a $15,000 bond on 2, $1,000 bond on 3, pretrial release, GPS monitor, no victim contact. In addition to the allegations, Mr. Ellis in 2018 was arrested for domestic violence battery by strangulation and misdemeanor battery against the same alleged victim. Those charges were dropped. 2015, grand theft. 2015, he was convicted of strong arm robbery, carrying concealed weapon by a convicted felon, aggravated assault, a deadly weapon, and domestic violence battery by strangulation. That was against a different alleged victim. Resisting without violence, 2011. 2009, possession of cocaine with intent to sell, distribute, at or near a school or child care facility or park. Felon carrying concealed weapon and attempted tampering physical evidence. He was sentenced to just over 36 and a half months state prison as a habitual offender. 2011, he was arrested for domestic violence battery against a different alleged victim. That was dropped. He has other priors that precede but the ones I've advised the court over are the most relevant and recent.
Mr. Romero?
Judge, Mr. Ellis is not going to be able to afford the $15,000 bond. He's 39 years old, been here his whole entire life. He's currently looking for employment, so he has no income coming in. My understanding on counts 2 and 3, I believe it's not in custody cases, which happened sometime last year. My understanding, Judge, he's looking forward to having his day in court and disputing these allegations. We're going to be requesting a photo order so we can also photograph the injuries that Mr. Ellis sustained. But Judge, like I said, he's not going to be able to afford $15,000. We're requesting on count 2, $3,500 bond, and count 3, with the $1,000 bond is reasonable, Judge.
I'll sign the photo order.
Your Honor?
Yes.
Just so the court, for the court's edification and the timeline here, the domestic strangulation battery case from 2018, what happened was we dropped the strangulation, filed a misdemeanor battery. That was dropped October 29, 2019. So that's where the no contact order got lifted. And this allegedly occurred December 2nd, 2019.
I understand. Bond on count 2 will be set at $7,500. The bond on count 3 will be set at $1,000. If Mr. Ellis posts his monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor, and there will be an order of no victim contact. Mr. Ellis, so that you understand the no contact order, that means no being in the same place at the same time as this alleged victim. Since you'll be wearing a GPS monitor, that'll include a 500-foot stay-away order from her. The no contact order also means no phone calls, no text messages, no third-party contact, no social media contact. I'm also going to impose an order that you possess no weapons, firearms, or ammunition. Based on your priors, that should go without saying, but I'm going to impose it anyway, just for safety's sake. That means if you are in possession of any weapons, firearms, or ammunition, they are to be surrendered to local law enforcement. Do you understand that, sir?
Yes.
Thank you. Trayshawn Ellis.
He's here at Main, Judge.
Thank you. Good morning, Mr. Ellis.
Hi.
Mr. Ellis, you are before the court on 6 charges. They are all capiases. Count 1 is a felony capias related to a charge for possession of cocaine, which your division judge has placed a no bond hold on. Count 2 is a traffic capias related to a driving with suspended license charge. Counts 3, 4, and 5 are each felony capiases related to charges for tampering with a victim, domestic battery, and possession of cannabis. Your division judge has placed no bond holds on those capiases. Count 6 is a traffic capias related to a charge for driving with a suspended driver's license. I find probable cause. In light of the no bond holds, do the parties wish to be heard on counts 2 and 6?
No, Judge.
No, Judge.
All right, Mr. Ellis, you'll be seeing your division judge on Monday morning. Kedron Shaw.
Approaching, Judge.
Thank you. Good morning, Mr. Shaw.
Good morning.
Mr. Shaw, you're before the court this morning on 12 charges. Counts 1 and 2 are each a separate charge for possession of a forged driver's license or ID. 3, false ID given to law enforcement. 4, carrying a concealed firearm. 5, grand theft of a firearm. 6 is a felony violation of probation with a no bond hold. 7, grand theft auto. 8 is battery causing bodily harm, dating violence. 9 is a felony probation violation with a no bond hold. Counts 10, 11, and 12 are out-of-county felony holds. Those are all out of Leon County and have no bond holds. I find probable cause. I do see Mr. Shaw has a hearing before his division judge on Monday morning. In light of that, do the parties wish to be heard on the remaining counts?
Not at this time, Judge.
Only thing I ask, Your Honor, on charge number 8, the battery,
Yes.
if the court would order no victim contact with Ashley Barnett.
All right, so Mr. Shaw, on the battery charge, there will be an order of no victim contact. No victim contact means no being in the same place at the same time as the alleged victim. That also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that?
Understandable.
Thank you. Michael Roberts.
Mr. Roberts, come on up, please.
Good morning, Mr. Roberts.
Good morning.
Mr. Roberts, you are before the court this morning on 2 charges. Count 1 is a traffic capias for driving with a suspended driver's license. 2 is a misdemeanor capias related to a petty theft charge. I find probable cause, and I'll hear from the parties.
Judge, Mr. Roberts wishes to resolve these matters today. We want to know if the state had a plea offer.
All right.
One moment, Judge. No, Judge, it looks like there's going to be restitution on the theft. On the, if Mr. Romero would like, I could look into the DWLS.
One moment, let me let him know.
Okay.
Judge, yeah, he's still interested in trying to see if we can resolve count 1, the driving offense.
Okay.
All right, let me pull his driving record. Your Honor, from what I could tell, this would be a first. State's offer would be a withholding court cost.
Judge, on the driving offense, he wishes to accept the state's offer.
Okay. Mr. Roberts, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. And Mr. Roberts, do you understand everything that's been discussed here today?
Yes.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
All right. And do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, sir? Guilty or no contest?
No contest.
All right. I accept your plea and find that it's freely and voluntarily given. Your sentence as to the traffic charge only will be a withhold of adjudication plus court costs. Good luck to you,
And
Mr.
Judge,
Roberts.
just for Mr. Roberts' certification, the
Yeah.
petty theft, what, when did it take place and what store was it?
It was,
I'll have Mr. Linder provide that information because I just have the KPS.
I don't know that it was from a store, so, I mean, if he's wondering what store's alleging, it makes me wonder, but he might know something I don't.
No, he doesn't know anything about this.
Well, then, when he
That's why
goes to
we're
see his
asking.
judge, they'll advise him of it, but it wasn't at a store.
He has, just so Mr. Roberts knows, he's going to have a hearing in front of his division judge on Monday morning on that matter. All right, so he can address it then. Next will be Lamont Green.
Mr. Green, come on up. He's approached, Judge.
Thank you. All right, good morning, Mr. Green. Mr. Green, you're before the court this morning on one charge of trespassing of an occupied structure or conveyance. I find probable cause, and I'll hear from the parties.
Judge, Mr. Green wishes to resolve this matter today.
Offer be 10 days, Your Honor. Mr. Green continues to come through this division. He's been advised by multiple judges to stop trespassing in various locations. I can tell you, in the CCIS system, there's 106 hits for Mr. Green. He's been arrested January 13th of this year, December 26th last year, December 4th, November 23rd, November 9th, September 23rd, July 14th, July 11th.
Judge, respectfully, Mr. Green is does not want to accept the 10 days. He wishes to see if the court's willing to give him an ROR.
I am not willing to do that. His bond will remain at $100. Thank you. Michael Smith.
He is approaching, Judge.
Thank you. Good morning, Mr. Smith.
Morning, sir. Ma'am, how you doing?
Well, Mr. Smith, I'm not very happy to see you this morning.
I'm,
You don't need to comment on it. I just want to say we had a lot of contact in Hollywood last year, and you seem to be on a good track, so hopefully this isn't going to be a deterrent to that. Today, you are before the court on a charge of touch or strike battery. I find probable cause, and I will hear from the parties.
Judge, Mr. Smith's financially indigent. He's homeless. He's 53 years old. Judge, he's asking to be released under supervision. It was his birthday yesterday. Judge, he got arrested on his birthday.
I'm aware.
Okay. Your Honor, I'm asking that the court keep the bond in place. I won't go into the details, but the court is aware of what's being alleged, and it could have gone a lot worse.
I understand. This time I'm going to leave the bond in place. There will be an order of no victim contact. Mr. Smith, I don't know if you know the alleged victim or not. Whether you do or not, please understand the no contact order means no being in the same place at the same time. It also means no phone calls No text messages, no third-party contact, and no social media contact. Do you understand?
Yes, ma'am.
All right, thank you. Julius Hickson.
Mr. Hickson? Approaching, Judge.
Thank you. Good morning, Mr. Hickson.
Good morning.
Mr. Hickson, you're before the court this morning on a misdemeanor capias. This is related to a charge for DUI. Your division judge has placed a no bond hold. I do see you have a hearing before her on Monday morning. For the record, I find probable cause. And so at this time, that no bond hold will remain in place until you see her on Monday morning. Thank you.
Hello, sir.
Willie Clark.
He's approaching, Judge.
Good morning, Mr. Clark.
Good morning, Your Honor.
Mr. Clark, you're before the court this morning on 2 misdemeanor capiases. These relate to charges for petty theft and trespassing. I find probable cause, and I'll hear from the parties.
Judge, Mr. Clark wishes to resolve this matter. We want to see if the state had a plea offer.
Hold on one second. I'm sorry, Your Honor, this is on,
This is Mr. Willie Clark. Does the state have an offer on these charges?
Your Honor, on the 2020 case, I understand that there's two different cases. It's a withholding court cost, and on the 2000, that's the 2019 case, also withholding court cost.
All right, so both will be a withholding court costs.
Judge, he wishes to accept the state's offer.
All right, Mr. Clark, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. Mr. Clark, do you understand everything we've discussed so far today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
All right. And do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, sir? Guilty or no contest?
No contest.
All right, Mr. Clark, I accept your plea and find that it's freely and voluntarily given. Your sentence as to both charges would be a withhold of adjudication plus court costs. Good luck to you.
Your Honor,
Yes.
if we could address a separate matter briefly.
Yes.
Stephen Ramirez Tabarez, that was the case, Your Honor, found no probable cause, reset for 24 hours.
So that was the high school?
Yes.
Yes.
I received word that he's being represented by Neil Kirch. I just got off the phone with Mr. Kirch.
Yes.
And I can represent him as an officer of the court, and I also have a number if you want to reach out to him, that based on the totality of the circumstances, he would prefer to concede to PC, have a bond set now, so that his client could be bonded out. And we have an agreed amount. So I have his number if you want it. I don't know if either if we could have the jail bring Mr. Ramirez back or reset it for the afternoon.
At this point, why don't we reset him for the afternoon? And that way we'll have his paperwork back in order and everything, and that won't cause any complications on their end. All right? Okay. So if somebody would please make sure that that gentleman gets reset on our PM docket so that the jail knows and so that I have the paperwork for him.
And that was the gentleman that was on page 28, correct? Ramirez Tabarez,
28.
Stephen?
Yes, that's correct.
Okay, I'll let the deputies know.
Thank you very much.
These cases that you did.
I'm sorry. All right. So next up will be Jeffrey Adderley. Okay, what's the correction?
Mr. Adderley, come on up. He's approaching, Judge.
Thank you.
The charges that's corrected has nothing to do with magistrate. We need to just add it for record purposes.
Okay.
However, count 3,
Yeah.
that's Orange County.
Orange instead of Miami-Dade, you mean?
Yes, ma'am.
Well,
Okay.
and also probably
And
not.
then he was also, there were 2 other teletypes with the whole court date. So he has Orange County.
Well, I also figured he wasn't on pretrial for a civil writ.
Yeah, I noticed that also. So, let me just ask this, since the counts 4 and 5 are coming up, now,
Count 4 and 5
it's,
are for Dave, so it's not the magistrate, we just wanna attach the paperwork.
okay, just so that he knows about it.
And
Okay,
then on count 3, it should reflect the out-of-county hold.
all right, I'll make that change. That's fine. All right. All right, good morning, Mr. Adderley.
Morning.
Mr. Adderley, you are before the court this morning on the following charges. Count 1, driving while license suspended, first offense. 2, attaching a registration or license plate not assigned to the vehicle. 3 is an out-of-county misdemeanor hold from Orange County. That is not for magistrate. There are also 2 additional charges. They are out-of-county holds from Miami-Dade County. Those are not for magistrate. I find probable cause, and I will hear from the parties on counts 1 and 2 at this time if they wish to be heard.
Judge, nothing to request in reference to those, but as far as what was here before me, what I spoke to Mr. Adderley about, I was
Yes.
unaware that he had misdemeanor out-of-county holds, and I believe the court mentioned a Dade County hold.
Yes.
Are there bonds attached to those holds or anything?
Yes, so I'll read you what I have on the corrected booking.
Thank
On the Orange County out-of-county hold, that's the third, number 3, that has a civil purge amount of $2,000. And the 4 and 5, which are the Miami-Dade out-of-county holds, those are Department of Revenue holds, and their purge amounts are $2,500 and $1,250.
Nothing to request in reference to the Broward offenses, Judge.
Okay, thank you. All right, next will be Terrence Hammond.
I'm sorry, Judge, who did you call?
That's all right, it's Terrence Hammond.
Mr. Hammond, come on up, please. One moment, Judge.
Okay.
He's coming, Judge, from...
We're getting there. Mr. Shade, I'll do yours next. Thank you. You missed cake the other
Judge,
day.
if we can put him on recall, he's in back.
Okay, that's fine. I'm gonna go ahead and address Mr. Shade's cases. He's only got 2. All right.
I said happy birthday.
All right, so I have first up on page 15, David Marco.
He's approaching, Judge Main.
Thank you.
Thank you, ma'am. Thank you, sir.
Good morning, Mr. Marco.
Good morning, ma'am.
Mr. Marco, you're before the court this morning on a misdemeanor capias. This relates to a charge for trespassing. I find probable cause, and your attorney, Mr. Shate, is present in the courtroom with me. Mr. Shate, what are we doing in Mr. Marco's case?
There'll be a time served offer for Mr. McCoy, Judge.
Excuse me, ma'am. When
Yes.
was this?
Uh,
What year?
I will tell you. This is an
Thank
old
you.
one. This is an old one. It says 2000. Let's see. This is 2000. It's a 2012 capias on a 2011 case.
Oh, wow.
Yeah, it's an old one, Mr. Marco.
Yes, ma'am, and I never even got a notice, so I had no idea that I was gonna show up in court, otherwise I would have.
All right, well, we have you here today. So what Mr. Shate has told me is that if you want to resolve the case today, then the offer would be an adjudication time served. Do you understand that?
Judge, I'm not sure if this falls into the category that had to be dismissed. We
And
were
so
unaware
what do I
it was
do, ma'am?
2011.
I'm sorry, what was
I'm
that?
sorry.
That's
Hold on
okay.
one second, David. We were unaware it was 2011 case too because it was a new pickup.
Yeah.
I'm not sure if this falls in the.
Yeah, I'd like to,
Hold on a second,
if I
Dave.
could,
Sir, hold on a second. I'm not sure if this
Okay.
if
falls
I
into
could,
the
I'd
area
like to
where it's
resolve it
allowed to
and
be
get it out
dismissed.
of my,
Okay.
get it out of my jurisdiction.
Okay, Mr. Marco, give me 1 second. Mr. Shate's telling me something about the case.
I'm not sure if this would be allowed to be dismissed
Thank
based
you.
on the timeline of being a U.S. citizen.
Do you have that for me to look at?
No, I thought, I know
Yeah, I
it's around
heard
the road, I
about
wasn't quite sure exactly, but it's time served anyways.
Okay. All right. So, Mr. Marco, if you want to resolve it, then it's an adjudication time served. If you want to accept that offer, then I'll ask you a few questions and then you'll be released later today. Is that what you want to do?
Yes, ma'am.
Okay, great. So I'm going to ask you a few questions now.
Yes, ma'am.
Will you first raise your right hand?
I'll do my darndest.
Okay, that's
Yes,
good enough for
ma'am.
me. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, great. Now you can put your hand down. And Mr.
Thank
Marco,
you.
do you understand everything we've discussed so far today?
Thus far, I do.
Okay, great. And is anyone forcing you to resolve this case?
No, ma'am.
All right. Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
To my best knowledge, yes.
Okay. And Mr. Marco, have you ever been treated for mental or emotional illness?
No, ma'am.
All right. And do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
That I do understand, ma'am.
Okay. And Mr. Marco, what plea do you wish to enter? Guilty or no contest?
No contest, ma'am.
All right. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication, time served. Good luck to you, Mr. Marco.
Thank you, ma'am.
You're very welcome. And next will be Russell Taylor on page 24. All right, and good morning, Mr. Taylor.
Good morning.
And Mr. Romero, I need you in on Mr. Taylor's case as well.
Yes, I'm approaching. I was speaking with the gentleman.
That's okay. All right. And Mr. Taylor, you're before the court this morning on 2 charges. Count 1 is a misdemeanor capias. That's related to a charge for dog bite where owners are liable. Count 2 is a felony probation violation, which has a no bond hold. I find probable cause. I do see that Mr. Taylor is set to have a hearing before his division judge on Monday morning. So in light of that, do the parties wish to add anything?
For the MO judge, just ask that it goes to the division.
All right. So I'll leave the $50 bond in place on the municipal ordinance violation. And Mr. Taylor, as I said, you'll see your division judge on Monday for the violation of probation case. All right.
Okay, thank you.
Thank
Good
you.
luck.
All right. That's all I've got for you today.
That's
huh,
all I
Mr.
got,
Shea?
Judge. Have a
All
great
right.
weekend. Happy
You too.
Valentine's Day.
Thank you. Same to you. Okay. All right. Next will be Brian Hernandez Pinaranda.
He's here, Judge.
Thank you. Good morning, Mr. Hernandez.
Good morning, Judge.
You're before the court this morning on 2 charges. Count 1, possession of alprazolam. Count 2 is disobeying a stop or yield sign. That count is not for magistrate. I find probable cause, and I will hear from the parties.
Judge, in speaking to Mr. Hernandez, I believe he has a clean record. He had, I believe, he was in pretrial diversion. I believe ultimately successfully completed, was dropped. He's a registered voter. He graduated from Andrews High School class of 2017. It's located in Pompano Beach. He's been here his whole entire life. He's 22 years old. Based that this is not a violent offense, Judge, his clean record and strong ties to community, I'm asking the court to consider releasing him ROR.
Your Honor, I would be asking for pretrial random testing.
All right, so Mr. Romero, I'll give him a choice. I'll either leave the standard bond or I'll put him on pretrial supervision with random testing.
Let me talk to him.
Thank you.
Judge, if we could just leave then the monetary bond in place.
Okay, thank you.
And Judge,
Yes.
Mr. Hammond is back.
Okay, great. I'll go ahead and take his case.
Mr. Hammond, come on up, please. He's approaching, Judge.
Thank you. All right, good morning, Mr. Hammond.
Good morning.
Mr. Hammond, you're before the court this morning on one charge of first-degree petty theft. I find probable cause, and I'll hear from the parties.
Nothing to add from the defense, Judge.
Anything from the state?
No, just no return order.
All right, so I'm gonna leave the $100 bond in place. And Mr. Hammond, there will also be a no return order to the Publix at 601 South Andrews Avenue. That means that you're not to return to that location. Do you understand that, sir?
Yes, ma'am.
Thank you. Charles Brown.
Mr. Brown? Charles Brown?
Charles Brown, it might be reflected already on the finding.
Is it a case number?
Should be
Mr. Brown is approaching, Judge.
Okay, thank you, Mr. Romero. I have on my finding sheet, count 4, there's a correction to the case number as 17. Is that not correct?
on count 4.
Okay, so what I have right now is 17013507 CF10A, is that right?
Yes, and that's on your finding,
Yeah.
but it's wrong on the book.
Okay, so you give me the corrected one. All right, good morning, Mr. Brown. Mr. Brown, you're before the court this morning on 5 charges. Count 1, driving while license suspended, habitual. Count 2, attaching a registration or license plate not assigned to the vehicle. Thank you. Counts 3, 4, and 5 are felony probation violations which have no bond holds. You are set to go before your division judge on Monday morning on the VOPs. I find probable cause, and do the parties wish to be heard on count 1?
No, Judge.
No, Judge.
Okay, all right, thank you. Donze Bannister.
Mr. Bannister is approaching, Judge.
Thank you. Good morning, Mr. Bannister.
Good morning, Judge.
Mr. Bannister, you're before the court this morning on 1 charge of burglary of an occupied dwelling, unarmed. I find probable cause, and I will hear from the parties.
Your Honor, I'm going to be requesting a $15,000 bond, no victim contact, no return. Obviously, this involved a hotel room, but for legal purposes, that was the person's residence at that time. And the victim was present in the room when Mr. Bannister unlawfully entered. Mr. Bannister appeared before the court last Friday. He was charged with unlawful possession of personal ID of another, resisting without violence. Your Honor, found no PC on count 1 because there just wasn't any mention of that, the facts to support that allegation. It stemmed from this incident, Your Honor.
Okay.
The ID in that case is the the victim's Georgia license that he was found to be in possession of.
Okay.
In addition, 2018, he was convicted of possession of substituted cathinones. 2011, burglary with damage done to a structure or dwelling and theft. He violated probation, was sentenced to 66 months in state prison. 2011, burglary of an occupied dwelling and grand theft. VOP, 66 months in Florida State Prison.
Okay. Mr. Romero?
Judge, Mr. Bannister's been living in our community for well over 20 years. He's 26 years old. He just got a job. He hasn't even started. It's a pressure cleaning company, but he's scheduled to start. He lives in Coconut Creek with his mother. My understanding is his mother takes care of his younger sibling, so our financial resources are quite limited and not going to be able to afford what the state has asked for. We're respectfully asking for a $5,000 bond on Mr. Bannister's behalf.
All right, the bond will be set at $7,500. There will be an order of no victim contact, as well as a no return order. Mr. Bannister, so that you understand the no return and no contact orders, that means that you're not to return to the location this allegedly occurred at. And whether you know the alleged victim or not, the no contact order means no being in the same place at the same time. It also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand?
I understand.
Thank you. Gary Thornton.
He's approaching, Judge.
Thank you. Good morning, Mr. Thornton.
How you doing, ma'am?
I'm well. Mr. Thornton, you're before the court this morning on 10 charges. Count 1, exposing sex organs in public. Count 2, DUI, alcohol or drugs, first offense. Count 3, refusing to submit to a DUI test. Count 4, driving while license suspended, habitual. Count 5, attaching a registration or license plate not assigned to the vehicle. Count 6, failure to register motor vehicle. Count 7 is driving a motorcycle without eye protection that is not for magistrate. Count 8 is not having the appropriate mirrors that is not for magistrate. 9 is first degree petty theft. And 10 is grand theft auto. I find probable cause, and I'll hear from the parties at this time.
Judge, Mr. Thornton advised me he's not going to be able to afford any sort of bond. He does side jobs as a handyman. Also, he does labor pool, in which he gets paid about $60 a day. He's been here his whole life. He's 48. He lives in Pompano Beach with his sister. He's been residing with her about for 3 months now, and she's not going to be able to afford to post his monetary bond. So he's asking to be released under supervision, Judge.
Okay.
No, pretty much everything but that, but. Your Honor, my pretrial's looking this up. I asked if she could check to see when Mr. Thornton was released from state prison. The reason being, he had 2018 felony battery due to priors. In March 12th of 2019, he was sentenced to 18 months in state prison. Okay. He's got a 2008 felony battery due to priors, battery on a law enforcement officer, resisting with violence, depriving an officer of a weapon or communications device, and DWS habitual offender. He was sentenced to 10 years in state prison as a habitual offender. 2008, possession of cocaine, a year and a day state prison. 06, DWS habitual offender, just over 17 and a half months state prison. 06, possession of cocaine, DWS habitual offender, same sentence. Another DWS habitual offender in 04, DWS habitual offender in 04. I mean, Your Honor, let me put it this way. With the amount of points that one gets for a DWS habitual offender, that he has gone to prison on 4 separate DWS habitual offenders is concerning, considering this is a driving matter. I think July 26th last year, he was in a state prison. Okay. Frankly, I think bond increases would be more appropriate than any type of reduction.
All right.
And Judge, my understanding, Mr. Thornton was released from incarceration July of 2019.
Yes, that's what was stated by pretrial, July 26, 2019. All right, at this time, I'm going to leave the standard bonds in place, just for the record, because I know there's a number of charges here that applies to count 2, count 4, and count 10.
Only other thing, Your Honor, I'm going to ask at this point in time, I understand his license is suspended,
Yeah.
but I ask that it would be a condition of his release, no driving until further order of the court.
Well, that should go without saying, but I have no problem imposing the order just for the record. All right, Mr. Thornton, if you do post your monetary bond, as a reminder to you, I am making a court order. You are not to be driving any vehicles. Since you do not possess a valid license, as I said, that should go without saying, but I'm saying it anyway. You are not to be driving any vehicles. Do you understand?
Yes, ma'am.
Thank you. All right. Noel Roman,
He's approaching, Judge.
thank you. Good morning, Mr. Roman.
Good morning.
Mr. Roman, you're before the court this morning on 2 charges. Count 1, possession of alprazolam. Count 2, disobeying a stop or yield sign. That count is not for magistrate. I find probable cause, and I'll hear from the parties.
Judge, nothing requested by the defense.
All right, anything further from the state? All right, I'll leave the $1,000 bond in place on count 1. Thank you. Edtwan Bailey,
Judge, I've been advised he's in regular court.
Your Honor,
yes.
I'm going to ask if Mr. Miller has no objection. The bond was originally set at $1,000. He posted it. Then he got arrested on a court-ordered no bond hold
Okay.
that he's still being held on. I'm asking that the court set this bond back at $1,000. His bondsman can just
This is
file
just
an
on-
affidavit to stay on the bond.
Okay, this is just on 3, right?
Yes.
All right. Okay, go ahead. Yes.
Keela Drake is his public defender. It's actually arraigned yesterday.
Judge, I have no objection to the state's request.
Okay, so I'll find probable cause for the record, and you said that was $1,000, Mr. Linder?
Yes, Judge.
All right, so I'll indicate $1,000 on here on count 3.
And do we have a bond amount for count 3?
That's the one that he's addressing.
Oh, I thought we were putting back the bonds on counts 1 and 2.
Oh, no, those are already, no. That was court ordered on a different case.
Very well.
Okay, so I'll set count 3 at 1,000 so that it essentially remains the same, and he'll address the no bond holds with the division judge. Okay, next will be Julio Mendoza Diaz.
He's approaching, Judge.
Thank you.
Good morning.
Good morning, Mr. Mendoza Diaz. You're before the court this morning on 2 charges. Counts 1 and 2 are each a separate charge for burglary of an unoccupied conveyance unarmed. I find probable cause, and before I hear from the parties, pretrial is standing up.
Your Honor, he was placed on pretrial in case number 20000252 CF10A for burglary on occupied conveyance and petty theft. He was placed on pretrial January 8th of this year. Pretrial is asking that you revoke his pretrial at this time.
All right, well, it looks like he was put on pretrial January 8th for very similar charges to what is being alleged today. Based on pretrial's request, I'm going to grant the request to revoke his pretrial services. Once again, just for the record, that's case number 2000252 CF10A. Because it was so recent in time and the charges are similar to that nature to those alleged today, I'm going to place no bond holds on the case that was on pretrial, and I'll hear recommendations from the parties on the case that's before me today.
Your Honor, requesting $5,000 per count.
Mr. Romero?
Judge requesting, because the court's already found no bond,
Yes.
Revoked his release and is holding him no bond. At this time, he just started employment. He hasn't gotten paid yet, so I'm asking for a $1,000 bond on each count.
All right, I'll set them each at $2,500. Yes.
Mr. Mendoza Diaz, the the case for which the court has revoked the bond, that case was filed yesterday, and so he'll be in front of his division judge for arraignment very soon.
Okay, all right, thank you for that information. All right, next will be J. Howard.
He's approaching, Judge.
Thank you. You have a correction?
It was
Is there a correction on his? Okay. All right, good morning, Mr. Howard. Mr. Howard, you're before the court this morning on 2 charges. Count 1 is a parole violation. Count 2 is a misdemeanor capias. That relates to a charge for resisting or obstructing without violence. I find probable cause. I do see that Mr. Howard's set to go for his division judge on Monday to address the misdemeanor matter. So in light of the no bond hold because of the parole violation, is there anything the parties wish to be heard on?
No, Judge.
All right.
Just for the record.
Yes.
We're gonna notify the parole record for this case.
Yes.
Because he was cases on a 19 case.
Yes.
But we believe that he was put on parole,
After?
after the fact, so that we will.
Okay. Okay, so, Mr. Howard, just so that you know what confinement status is telling me is that they're going to get in contact with your parole officer because they believe that the capias that you're here on today may have been issued before you were placed on parole. So they're going to contact them and verify that information, just so that you know. All right? Thank you. Wesley Michaud. Removed from the docket? Okay. All right, so next will be
He was
more.
deleted, Judge?
Yes, he was deleted from the docket. So that means next up will be Morris Choice.
Mr. Choice, he's approaching.
Thank you.
No, he's not.
All right. Good morning, Mr. Choice.
It was revoked.
Mr. Choice, you're before the court this morning on 6 charges. Count 1, dealing in stolen property. Count 2, false owner information provided for pawned items, $300 or more. 3, dealing in stolen property. 4, false owner information for pawned items less than $300. Counts 5 and 6 are each a separate charge for second-degree petty theft, third or subsequent offense. I find probable cause, and I'll hear from the parties.
Judge, and speaking of Mr. Choice, he's not gonna be able to afford, my math is correct, $13,250 to post a monetary bond. Now, my understanding, he just got a great job working for OIC where he cleaned city buses. He got that approximately 5 months ago, making about $14 an hour. He lives with his mother here locally in an apartment where they rent. She is on disability. Now, his mother knows that he is here. My understanding, Judge, is I believe on this not in custody capias, this is from last year. These are all nonviolent offenses. He's asking to be released, and I do understand as far as the dealing in stolen property, they're second-degree felonies, but he's asking to be released on level 2 pretrial so that he can fight this case from the outside, Judge.
And, Your Honor, I have confirmed that all of these cases are not in custody capiases.
Thank you.
Your Honor, state would be opposing non-monetary release. First, Mr. Choice has an open theft out of Palm Beach County right now. He was released from Broward County Jail July 26th of last year after being sentenced to 364 days on a new grand theft and 3 VOPs for 3 more separate grand thefts. So he's got 4 prior grand thefts in Broward, another petty theft in Broward from 2017, and a resisting without violence in 2012. What's that?
And Judge, he understands his record. However, on this case, he's looking forward to speaking to his public defender and relaying some information to the assigned prosecutor. But he's not going to be able to afford what's currently said. If the court's uncomfortable with placing Mr. Choice on level 2, then I would certainly at least ask for a bond reduction on counts 1, 2, and 3. Maybe his mother, using the services of bondsman, can afford to post his bond if the court were inclined to reduce each one to $1,000 bond. But he really does not know, and that's why we were asking for level 2.
Your Honor, and I understand Mr. Choice is looking forward to defending himself. I imagine the prosecutor assigned to the case is looking forward to prosecuting the case. But, and if there's additional information, his assigned public defender can bring that to the Assistant State Attorney's attention, and if he's still in custody, then the bonds can be looked at. But at this point in time, with his history of theft, a pending theft right now out of another county, and now these are all theft-related felony offenses, I really don't see any argument for mitigation that outweighs the aggravating factors.
All right, at this time, I'm going to leave the standard bonds in place. There will be a no return order. From what I'm seeing, and counsel, you can correct me if I'm wrong, I think that all of the out of custody capiases in this case relate to the Home Depot. Is that right? Are they different Home Depots, or or is it the same store?
One moment, Your Honor.
Oh, well, never mind. I'm looking at least two of them are different ones. Okay, so Mr. Choice, there's going to be a no return order, and that no return order will apply to each of the Home Depots that are at issue in these cases. All right, you understand that?
Yes.
Okay, thank you very much.
Okay, so what about the bond? Just send that? No, same price?
Your mic is on, Mr. Romero.
Oh.
Okay, next will be Samuel Jackson.
He's approaching, Judge.
Thank you. All right, good morning, Mr. Jackson.
Good morning, Your Honor.
Mr. Jackson, you're before the court this morning on one charge of aggravated stalking after an injunction of protection has been issued. I find probable cause, and I'll hear from the parties at this time.
Your Honor, I have a great concern for the victim in this case that Mr. Jackson is just not going to stop violating the terms of the court-ordered injunction, that he will continue to violate and have contact with her. Your Honor, I would note, and as you can see, he was brought here from Dade County. He's going back to Dade County. It would appear that that is in connection to criminal charges based on the allegations mentioned in the arrest warrant affidavit that occurred in Dade County. Intentionally ramming into the victim's vehicle while she was driving, fleeing and eluding law enforcement, and then he escaped custody by climbing out of the police cruiser's window. I did provide the court with a copy, and defense counsel, a copy of the victim's petition seeking injunctive relief and a protective order, just to, so the court has an idea of the totality of the circumstances. Just check and see any history. And just so you know, the open charges in Dade County: violation of injunction, aggravated stalking, fleeing and eluding law enforcement, aggravated battery, reckless driving, leaving the scene of an accident, escape, resisting without violence. He also, I'm requesting a $50,000 bond. Should he be eligible for release, pretrial, GPS level 1, no victim contact.
Mr. Romero.
Judge, besides the pending matters that I believe that are all open right now in Dade, I believe Mr. Jackson has no prior record, and he also believes two of the counts which the state has referenced, he believed was already the state attorney's office in Dade County already no info or took no action. Having said that, Judge, he's not working. He's looking for work. He's been here almost his whole life. He's 29, and he lives in Hollywood with his father, and his father is a retired officer. He's now a security guard, so he's not going to be able to afford the $50,000 bond. He's asking for $5,000 bond on his behalf.
And just so the court's aware, the Dade County State, from what I can tell in CCIS, the Dade County State Attorney's Office dropped the individual escape and individual flee and eluding cases to consolidate and merge them into the case I told you was open.
Yes.
Oh, and also, just so the court knows, I checked this, the state has already filed an information on this case, even though he was arrested on the warrant. So the state has looked into it and decided it was appropriate and that our burden was satisfied to be able to file this felony charge.
All right, the bond in this case is gonna be set at $50,000. If Mr. Jackson does become eligible for release and posts his monetary bond, he will be placed on pretrial supervision with a level 1 GPS monitor. I shouldn't need to say it based on the restraining order that's in place, but there will be an order of no victim contact in this case. Mr. Jackson, so that you understand the no contact order, once again, that means no being in the same place at the same time. Since you will have a GPS monitor, that will include a 500-foot stay away order from this individual. The no contact order also means no phone calls, no text messages, no third-party contact, and no social media contact. Do you understand that, sir?
Yes, Your Honor.
Thank you. Alfonso Bell,
Judge, on Alfonso Bell,
do you have a correction?
you can just write it on the file deed,
Okay.
count 5,
Yes.
the case number,
Yes.
1600
Mm-hmm.
8826 CF10A.
All right, there's like very small space in here. Can you just repeat it one more time?
Is that? Oh, yeah, sure.
That's okay.
1600 8826 CF.
All right. Good morning, Mr. Bell.
Good morning, ma'am.
Mr. Bell, you're before the court this morning on 6 charges. Count 1, burglary of an unoccupied structure, unarmed. Count 2, grand theft between $750 and $5,000. Counts 3, 4, 5, and 6 are each felony violations of probation, which have no bond holds. I find probable cause. I do see that you have a hearing before your division judge on Monday morning to address the probation violation matters. And so at this time, I'll hear from the parties on counts 1 and 2.
Just requesting a $3,500 bond on one, considering that he's on probation for multiple burglaries.
Okay, Mr. Romero.
Judge, nothing to request by the defense since he's gonna have to go in front of his division judge anyway to seek some sort of relief.
Okay. All right, so the bond on count 1 will be set at $3,500. I'll leave the standard bond in place on count 2. And Mr. Bell will go before the division judge on Monday for the VOPs. And Sheila, I'll just keep this to the side until you get that to me,
Is there
okay?
anything else?
All
Judge,
right, yes.
I just heard from court interpreters regarding Ms. Wong Craysorn.
Yes.
They're not going to be able to have anybody here before this afternoon, so can we go ahead
So
and
she'll put on the PM docket?
Thank you.
We're gonna check to see if she's still in custody.
Okay, because, yeah, I was being told that she may have already been processed for the immigration hold, so if you guys want to check that now, just let me know if we need to reset her or not. Let me just find out from them first before you cancel.
See the docket?
She's still here? All right, so, Mr. Romero, on, Shen Therat Wong Craysorn, she's the one that needs the Thai interpreter.
Yes.
She has an ad charge, so we're gonna put her on the PM docket because the interpreter can't come until the afternoon.
Judge, I'm calling
ma'am.
Paul Ryan to
I
let
don't
him know.
think she's at main, Judge.
She's not, where is she?
Yes, I'm here, ma'am. Paul
Oh,
Ryan.
oh,
I heard what you said. I heard what you said, ma'am.
okay, all right, thank you so much,
Deputy.
Deputy, I appreciate it.
Okay.
All right, and will you hold on to that one for me for this afternoon? Thank you. All right, let's keep moving. I'll go back to Maine. Next will be Jeremy Nelson.
He's here.
Thank you. Good morning, Mr. Nelson.
Oh, good morning.
Mr. Nelson, here before the court this morning on one charge of lewd or lascivious behavior where offender is older than 18 years of age, victim less than 16 years of age. I find probable cause. Are you standing up? And pretrial is standing up, so I will hear from her at this time.
Your Honor, he was placed on pretrial pretrial of case number 18000045, MO40A, for trespassing private property. He was placed on pretrial December 17th. We're asking that you revoke his pretrial at this time.
And, Your Honor,
Yes,
obviously, I'm not going to take any position on that. It's an MO case.
I understand.
I am going to be requesting a $25,000 bond, pretrial release for the GPS level 1. And I understand that the court may be revoking, but the reason I'm asking is, in addition to the allegations in this case, Your Honor, Mr. Nelson has a pending exposure of sexual organs in county court. The allegations in that case are that he followed a 17-year-old victim down the street. He called out to her. When she turned, she witnessed Mr. Nelson exposing himself and masturbating. Taking that into consideration with the allegations in this case, I do believe he poses a danger to women and children in the community, Your Honor.
Is he out on bond on that case?
I'd have to check what the,
That's a Broward case, you said?
it is a Broward case. If I have one moment, I'll
Go ahead.
check what his release conditions are.
Yes.
Yeah, Your Honor, it's a 2017 case. It's been going on for a while because of competency grounds issues. The last time he was picked up on the case, he was ROR'd on the charge. It was before Judge Evans. I believe it is now before Judge Pohl.
Carol?
He can't afford anything, Judge.
All right. I'm going to grant pretrial's request to revoke his pretrial services in case number 18000045MO40A. In that case, I will set a bond. It'll be set at $5,000. The case that's before me today on the new charge, bond will be set at $25,000. Mr. Nelson does post his monetary bond. He'll be placed on pretrial supervision with a level 1 GPS monitor. And there will be an order of no victim contact.
Your Honor, I apologize.
Yes.
I didn't mean to interrupt if you're going to order anything else. I also meant to ask for no contact with minors.
That's fine. Based on the circumstances, I have no issue with that request. So there will also be an order that Mr. Nelson have no contact with minors. Mr. Nelson, so that you understand, specifically with regard to the no victim contact order, whether you know the alleged victims or not, that means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media contact. With regard to my order that you have no contact with minors, that means you are not to have any contact, whether it is physical, whether it is over the phone, whether it is over social media, any type of contact between yourself and minor children under the age of 18 is prohibited until further order of the court. Do you understand that, sir?
Yes.
Thank you. Next will be Daniel Payne.
Medical reset, Judge?
Okay. Patrick D'Amico.
He's here present, Judge May.
Thank you. Good morning, Mr. D'Amico.
Good morning.
Mr. D'Amico, you are before the court this morning on 4 charges.
Judge, I have an argument as to 3 of those.
That's fine. Count 1 is for second-degree petty theft, third or subsequent offense. 2, first-degree petty theft. 3, second-degree petty theft, third or subsequent offense. And 4 is first-degree petty theft. Mr. Miller, I'll hear your argument at this time.
Your Honor, I have the probable cause affidavit for 1 count.
There's additional PC affidavits.
I looked for another PC. I couldn't find it. In any case, there's 1 alleged theft, and he's charged twice, both petty theft and felony petty theft. So I'm arguing that there is no allegation.
There are additional PCs.
But I don't have
I know,
those.
but
I've
if you
only
want to
got.
All right, gentlemen, I don't need you to argue on the record here at first appearances. If Mr. Miller doesn't have a copy of the probable cause affidavit, I'm more than happy to give him a moment to obtain those and to read them.
I don't need to attach it to this, just, that's for a separate case. And it's an MO, so.
Okay, so, thank you, Mr. Linder. So essentially, we have 2 allegedly stolen bikes
Okay.
and 4 counts. So we're not adding up here, Judge. I'm just arguing there's only probable cause for the petty theft twice. There's no indication in the PC that he has been convicted 2 or more times to make this a felony petty theft. And so I would argue that there's only PC for count 2 and count 4.
Okay, Mr. Linder.
One moment, Your Honor. Let's go with these.
Thank you. And so, Your Honor, Mr. Linder has provided what appears to be 2 previous convictions for felony petty theft.
Yes.
That being the case, then we only have probable cause for counts 1 and 3, and I would ask the court to find no PC for counts 2 and 4.
That's fine, Judge.
All right. All right, so in light of that, I will make a probable cause finding as to counts 1 and 3 only, no probable cause as to counts 2 and 4. And now I will hear the parties' recommendations as to bond and release conditions.
Judge, unfortunately, Mr. D'Amico is, no one's at this time going to be able to post his monetary bond. What happened when he was arrested, he was given the opportunity to contact his family. He tried to contact his wife. He found out that his wife last night was staying in the hospital. She was pregnant, so she's giving birth. He doesn't know if she gave birth this morning or if she's still in labor.
I've been able to use the phone.
So, Judge, right now, no one's going to be able to post his monetary bond. He's been here in our community for well over 20 years. He's working. He's asking if the court would consider releasing him on a pretrial release so he can be released and be there for his family, Judge.
Well, Your Honor, first of all, the flip side to that is according to these allegations, while his wife is almost due, he's allegedly out stealing bikes. Your Honor, I can tell you, I would ask at a minimum that the bonds be kept in place. Frankly, they should be raised to $1,500 each. He just got out of jail January 17th of this year, and that was after he was sentenced to 270 days in county jail on total cases that include 2 counts of grand theft, 3 counts of felony theft. He was arrested on May 29th of last year. He was already out on pretrial. When he was arrested, there was a warrant for his arrest for violating pretrial because he removed a GPS monitor. The warrant was signed March 18th of 2019. Law enforcement was unable to determine where he was for 2 months, and he was only taken into custody at that time because he was committing new thefts.
Judge, what I wanted to ask is, the way Mr. Lender made it say it's recent, maybe even yesterday, when are the alleged date of incidents?
One of them is February 12th. That's the most recent. The other is February 2nd.
Pretty recent.
He was arrested yesterday.
Judge,
I'll just
we're
pay the
still,
bond. I'll just pay the bond. I'm not gonna.
nothing to add, Judge.
Yeah. Just keep the bonds the same. Pay the bond.
All right. The standard bonds are going to remain in place on counts 1 and 3. There will also be a no return order to the LA Fitness located at 1000 North Federal Highway in Pompano Beach. Mr. D'Amico, do you understand the no return order?
Yes, ma'am.
Thank you. Curtis Brown,
Bonded, Judge?
thank you. Omari Thompson,
He's approaching, Judge?
thank you. Good morning, Mr. Thompson.
Good morning.
Mr. Thompson, you were before the court this morning on one charge of carrying a concealed firearm. I find probable cause, and I'll hear from the parties.
Judge, I'm going to be requesting if the court will consider releasing Mr. Thompson on pretrial release. He lives here locally.
Mr. Linder?
I have no objection, would ask for a condition that he is not to be in possession of any firearms, weapons, or ammunition.
All right, so Mr. Thompson, I'm going to ROR you on this charge and release you to pretrial supervision. Mr. Romero is going to give you some information about pretrial there. Since today is Friday, you will have until Monday to report to pretrial supervision. They're closed on Monday? Oh, okay. So pretrial is telling me that pretrial supervision will be closed on Monday, so you have until Tuesday to report to them. If you fail to report to them by Tuesday, then a warrant will be issued for your arrest. Do you understand?
Yes, Judge.
Okay. Additionally, there will be an order that you possess no weapons, firearms, or ammunition. If you are in possession of any of those items, they are to be surrendered to local law enforcement
same woman as
until
yesterday.
further order of the court. You understand?
Yes, ma'am.
All right. Thank you very much.
What's your email?
Your mic is on. Mr. Miller, your mic is on.
I'm sorry. Oh.
Okay, next will be Nikhil Harvey.
He's here present, Judge?
All right, good morning, Mr. Harvey.
Good morning.
Judge,
Yes.
I just wanted to advise the court that the alleged victim in this case is currently a public defender client who we are defending for a grand theft on a 65-year-old. He also has several other crimes of moral turpitude and actually did prison time both for crimes of moral turpitude and driving on a suspended license. And I know how much that drives the state crazy.
Well, no. What's driving me crazy, what would be driving me crazy if I was Mr. Michael, is that a lawyer from the office that's representing me is essentially throwing my criminal history out there. I don't know, I don't want to say what argument Mr. Miller's making about this gentleman, but frankly, it's really not, shouldn't be taken in any consideration. And I don't know why Mr. Miller's throwing that out there before the court's even made a probable cause determination.
Your Honor.
Excuse me, I certainly don't advise the court of a defendant's criminal history before the court's made a probable cause determination.
All right.
Judge, the court has to consider everything when making a probable
Gentlemen,
cause.
you're both getting ahead of me. We only have a couple of cases left on this docket. Please be quiet so that I can get through this, and then I will hear from everyone. Mr. Romero is the best behaved out of the three of you today, and he has to be present at the jail. All right, Mr. Harvey, for the record, you are before the court this morning on 3 charges. Count 1, robbery by sudden snatching without a firearm or weapon. Count 2, aggravated battery causing bodily harm or disability. Count 3, burglary of an unoccupied conveyance unarmed. I find probable cause for these charges, and at this time, I will hear from the parties with their recommendations for bond and release conditions.
Judge, just to answer the state's concern, the court has to take everything into consideration, including the possible veracity of the alleged witness
I
in this
understand,
case.
Mr. Miller. You've put your
The
your thing on
information
the
that
record.
I shared with the court is a matter of public record, has nothing to do with confidentiality. So there's no breach of confidentiality here. I'm telling the court what I'm finding here on the clerk's computer.
All right, that's fine. Mr. Linder, I will hear the state's recommendation, and then I will
Your
go to
Honor.
Mr. Romero.
Your Honor, I'm requesting a $20,000 bond on count 1, $10,000 bond on count 2, $3,500 bond on count 3, pretrial release with a GPS monitor, no victim contact. Mr. Harvey is currently out right now on 2 pending cases, carrying concealed weapon, resisting without violence, and loitering and prowling. Another case for resisting without violence and criminal mischief. He just pled out 5 days ago to a trespass and unlawful use of false name identity. 2018, he was convicted of burglary of a structure. 2016, grand theft. 2016, felony criminal mischief. 2016, theft.
Thank you, Mr. Romero.
Judge, we don't have an objection as far as having them released under supervision of pretrial, but as far as a monetary bond, Mr. Harvey cannot afford anything. Right now, he says he works when he can for a labor pool. He's 24 years old. He lives with his mother in Lauderdale Manors. She can't afford to post anything, Judge, so financially, he's indigent.
$500.
I do just want to note, for the record, because of the information that's been provided about the victim today, I'm not going to make any statements about the victim's history, but I just want to note that the officer did note in the probable cause affidavit that he reviewed the video surveillance footage from the 7-Eleven this allegedly occurred at, and indicated that both the alleged victim as well as the officer in this case identified Mr. Harvey as one of the individuals involved in this alleged incident. Bond on count 1 is going to be set at $10,000. The bond on count 2 will be set at $5,000. And the bond on count 3 will be set at $2,500. If Mr. Harvey posts his monetary bond, then he will be placed on pretrial supervision with a level 2 GPS monitor, and there will be an order of no victim contact. Mr. Harvey, as to the no contact order, whether you know the alleged victim or not, no contact means no being in the same place at the same time. Since you'll have a GPS monitor, that includes a 500-foot stay away order from this individual. The no contact order also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that, sir?
I understand that. However, Miss, the bonds that you set in place is out of my league. I can't afford it.
Well, Mr. Harvey, to be honest with you, with regard, I mean, what I'm being told is that you're out on bond in 2 other cases. And I could very well revoke your bond in those cases and hold you no bond, but I'm not going to do that today. Instead, I am placing bonds on you, and if there's an issue with it, then your attorney can make a motion before your division judge to address that issue. All right? Good luck to you, sir. Theophilus Joyce.
He's approaching, Judge.
Thank you. Good morning, Mr. Joyce. Mr. Joyce, you're before the court this morning on 1 charge of grand theft auto. I find probable cause, and I'll hear from the parties.
Judge, Mr. Joyce is requesting to be released on pretrial release.
Okay.
One moment, Judge. I don't have an objection to pretrial, Judge.
Mr. Joyce, I'm going to ROR you on this charge and release you to pretrial supervision. Mr. Romero is going to give you some information about pretrial there. Since pretrial is going to be closed on Monday, you'll have until Tuesday to report to them. If you fail to report to them by Tuesday, a warrant will be issued for your arrest. Do you understand? All right, thank you very much.
This doesn't make any sense.
Next will be Demetrius McDuffie.
All right, Your Honor.
Thank you. And this is a change of charge. All right. Good morning, Mr. McDuffie.
Good morning, y'all.
All right. So, Mr. Linder, let me just confirm with you. The original charge was false imprisonment of an adult or child under 13, and it's being changed to armed false imprisonment. Is that correct?
That is correct.
And Your Honor, this is second-degree felony. Your Honor, already found proof evident presumption great in count 1.
Okay.
We're just asking the court for an order just indicating that the finding of proof evident presumption great is without prejudice. It didn't appear on the original finding.
Your Honor, he's entitled to a bond on this charge. That's why I printed out a
Yeah, I
copy
think
of
the no bond was just on count 1.
Count 1
the
and
other
2.
2 counts.
Oh, I'm sorry. There were 2 counts?
Yeah.
I don't have it in front of me, so that's why I'm not
There
saying.
was, I believe, armed false not armed.
Home invasion, robbery with a firearm or deadly weapon, robbery with a firearm or deadly weapon.
All right, so he has no bond hold on counts 1 and 2?
That's correct, Your Honor.
Without prejudice, obviously, I understand.
May I approach?
Do you have something? Yeah. Oh, yes, thank you. Appreciate it. Okay, that's fine. I'll sign that.
And we have no objection to whatever bond the court wants to set. We're going to have to take this up with the judge.
Okay, that's fine. So just for the record, I'm gonna make a probable cause finding for the change charge. And, Mr. Linder, what's the state recommending?
Based on the allegations, I would be requesting a $10,000 bond.
All right, so Mr. McDuffie, since you have no bond holds on the other 2 charges, I'm going to set the bond on this count at $10,000. Based on what Mr. Miller is telling me, They're going to have to go before your division judge to address those issues anyway. So if there's a problem with this one, that can be addressed with the division judge. All right. Good luck to you, sir. And then last is going to be Kajeffrey Nathan.
Is it the main?
Reset, Judge?
Well,
He's a medical reset, Mr. Romero?
No, he's in court 5900, Judge.
Oh, okay. Yes, Mr. Linder, what do you want to say?
Judge, we can go ahead and waive his presence for the purposes of this hearing.
Well, the
This is
bond has to be set. If Mr. Miller wants to waive his appearance, that's fine, but if,
Well, let me ask this. This is a change of charge for today. Based on the warrant that I was handed, is he being held no bond on another charge?
no, he was at charge with murder in the second degree. Your Honor, found proof evident or presumption great.
Yes.
The state has filed the charges of manslaughter. So he's bond eligible now.
All right, so why don't we'll reset him, and when he comes in, we'll address it since he's in court, okay?
Oh, yeah, I mean, actually, it'll work out. I believe Judge Bober's here this weekend, and it's Judge Bober's case. So.
Okay, all right, so that's fine with me. We'll have his case reset.
Very well, Judge. Thank you.
All right, so let me just ask, it's almost 12 o'clock. Is 1 o'clock going to be all right for the jails to restart? Let me just confirm with them that that's fine.
And Your Honor,
Yes.
I did confirm the Thai interpreter will be here at 1:30.
Okay, great. Okay, we'll say 1 o'clock, and if there's a problem, then everyone will just let me know. All right, thank you.